I'd like to call the meeting of the Legal Legislative Committee into order today. We have a problem with my phone that's had information on it. That's what I've been trying to work on at this moment. I'd like to thank the members for being here today. I know this was a relatively short notice in the timeline. It's been difficult for some of you. I really appreciate you working this schedule in. We were trying to work it where we could have our attorneys here today as well as each of you. We do have a quorum. We'll pledge allegiance to the flag. If we would get Commissioner Slater, if you don't mind, send the flag. I have prayer. Pledge allegiance to the flag of the United States, to the republic for which one nation, under God, indivisible, with liberty and justice. We'll have a moment of silence in prayer. Lord, we thank you that we live in this country for this opportunity, public. Those decisions relate to all of us. Blessings on this time. We have a relatively full agenda today. We'll be looking at a request from one of our members that we deal with signage. We'll take that one first. I guess we will take a look at the minutes first. Will we not? Yes. You have a chance to review the minutes of our last meeting. Any corrections, additions?
Mr. Chair, I move that we approve the minutes.
Moved and seconded to remove the minutes. All those in favor, say aye.
Aye.
Aye. The first order of business on that, I believe, is to look at the request that came from one of our members that we look at signage on the auction and sales items that we do have that come before us from time to time. It came up in our last decision that we made on the signage, and the request is that we look at that as a committee. All of discussion on that matter of signage. Are we for it or against it? And if we're for it, how do we want to have it done? The floor is open for any discussion. No discussion. I assume that we're all for it, and we would like to move forward with that.
So I have a question. So what kind of signage are we talking about? Will we determine what is on the sign? Who will determine what is on the signage? How long will it be posted? Where will it be posted? Will it be in the paper? I think there's more questions than just to say we're for signage and vote and approve it in the end.
Right. Well, this was not the end. Just need to make sure that's what we want to do. We want to do signage. We want to do signage. I think Mayor advised me. I think there's a procedure that we do on those signs. I think we recommend it to the commission from here, and then it goes to one of our accounts, probably $5.99, and then it would go through a particular department. What do you suggest?
Right. If this committee approves the recommendation in the resolution that we do, it would say that when selling county property, a sign saying property for sale be placed on that property, along with the legal that Crystal puts in the paper. That one-time cost of the sign be paid out of your $5.99, and I guess it would be my responsibility to see if that sign goes up whenever you all approve. I was saying before the meeting, the hardest thing is going to be remembering to do it because we don't sell property very often, but we'll have a sign made, and if you want to specify size, you can do that, but we would probably do one something like we do for rezoning, and it'd be a one-time cost that we would save the sign and put it up then the next time we sell property.
Any discussion, motion we would like to make? Motion.
Yeah.
What we do with the signage? Can't make the motion. You don't have to. We're saying that it'd be done with $5.99. The funding would be $5.99.
Yeah, the one question I have, you want me to go ahead and spend the money and make the sign, the one-time sign, and have it for when we do it? Or do you want me to wait until you vote to sell some property 5 years from now and make the sign
The
then?
latter.
I think that makes more sense
Spoken
because
by-
the sign could get lost, but
Spoken by
whatever you want to do.
Yeah, signs are us.
Spoken by finance.
Mr. Chairman, at this time, I'd like to make a motion to incorporate that when Bradley County deems it necessary to sell property, that a sign is required. Asking the mayor to include that in the resolution and any contracts thereof. To put that on form of motion. Thank you.
Thank you. So moved.
Second.
So moved by Commissioner and seconded by Mylan Blake, seconded by Louis Alford. All those further discussion? All those in favor?
Aye.
Carried. Next order of business is one that's been brought to us in our last meeting that was moved to this committee. Moved forward that we look at the insulin challenge and the fact that there is a movement by the federal government as well as local governments to look at how we deal with the litigation that would be moving forward. The prompting of this particular committee to get this action assigned to us was it did come from one of our members that we needed to have direct dialogue. Josh Rogers would like to have direct dialogue with Mr. Jimmy Logan, who's with us today, and to have dialogue and then in our presence, and then we can agree and can move forward with the dialogue that would move forward. So I'll begin this section of our meeting with Josh. Would you like to open up with a question that you have or here?
Sure. Mr. Chairman, would you want to let the committee members of this committee ask their questions first, and then I can ask, or is it okay for me to go ahead? I just want to make.
Well, you're the reason that we established the meeting, but Cindy Slater could go ahead.
So I do have one question, Mr. Logan. The night that you first came and spoke to us about this resolution, and I agreed to be the one to bring it to the commission, I was under the impression it was an opioid resolution, because I think that's what was discussed that night, and someone can correct me if I'm wrong. And then I think we were somewhat surprised, or I was surprised when we got the resolution, it was not opioid, but it was dealing more with insulin drugs.
Let me,
Sure.
certainly what I was talking about, because the opioid litigation is essentially concluded. We still do have one case which you had previously approved, which is a state case dealing with opioid distributions by various pharmacies within the state of Tennessee. It's an independent of resolutions which have been made across the country with numerous class actions, which we are a part of, and the state of Tennessee then developed a statutory scheme for the disbursement of those opioid funds, and I think that was a part of Mr. Rogers' questions about this. We are looking at potentially numerous other drugs, not just insulin, but the diabetic treatment drugs, in which the pricing is incredible. Some of the commission members have come to my office and wish to obtain some of that information. It is price fixing on various items instead of an across-the-board listing of all drugs that are a part of the research which is going on. And as you may know, there have been significant discussions about the cost of insulin for a long, long time. This resolution only approves the involvement in the insulin and diabetic drug aspects. There are others we were going to include, but the data and the information, and this has been a subject of discussion since about 2015. Actually, Congress looked at it once before, took no action. Senator Kentucky had a press conference here about 4 weeks ago. That results from the different classes or cases which have been filed. What I've chosen to do is review all of those cases and wish for us to be potentially a recipient of benefits, which, as the county, we've incurred great deals of expenses, and perhaps there will be some disbursement provisions that are built into the class action. But there are about 10 cases which are out there, and I think I made reference to some of that. What I've done is chosen what I believe to be the best mass tort attorney in that case, which would pursue, and we would be a beneficiary of that. It is open to beneficiaries being states and things of that nature. And in response to Mr. Rogers' questions and comments about consulting with our local county attorney, I called the Tennessee Attorney General's office, spoke to the Consumer Division coordinator. She advised me that no one was available to discuss it in the Attorney General's office, but she told me what the answer would be. The answer would be, we cannot disclose to you whether we are or are not engaged in proposing our involvement in the litigation. And I said, well, please pass it up the line and see if the director of the Consumer Division, which handles these types of matters for the state of Tennessee. I did receive a call back from a really nice fellow, seemed to be exceptional, kind, and asking significant questions. His name, he was the person who was assigned once the director began to talk about it. His name is, and this is the individual I spoke to, his name is Austin Ostigai. He's been with the Consumer Division for 5 years in the State Attorney General's office. He told me that there was, to his knowledge, no action pending at this time within the Consumer Division, and he would like for me to give him the data and the information upon which they would rely if they wish to file an action. And I have shared with him that I'd be happy to cooperate fully, but that we would want to make certain that until such time as it was brought to the legislature's attention, that the benefits would go to those areas and those victims who are most concerned. We do have some other counties in Tennessee which have agreed to us pursuing that on behalf of those counties. So, and I don't know if Ms. Freiberg has found anything or anyone else, but you can look online. There's probably well over 1,000 entries of this concept of from dollar cost, $2 cost, charging people $300 to $700 each.
Mr. Blake.
This is like Commissioner Slater said, this is not opioid at all. The word opioid really isn't even ever going to be entered into this lawsuit if we even go there, right? So you mentioned a few minutes ago price fixing. And from what I understand, that's going to be pretty hard to prove. Do you have what you need to prove it?
I think
I mean,
that there
we're not in
is,
jury right
I
now.
think there's significant evidence, and I do agree that, well, there is significant evidence that numerous pharmaceutical companies have engaged in cooperating together and the pricing being placed at an unreasonable, and some people call outrageous, price, $300 to $700. That's sufficient to get you over the initial hurdle. Interestingly, in terms of our contract, there is no expense or cost to the people who participate in that class action. That's part of the contract that we have submitted to you
Yeah, I read the contract, but all the costs that are involved to get to, what's the word I'm looking for? A verdict. I'm not a lawyer, I don't know, but a ruling, what have you. Then the costs do come into play from whatever the award is. I apologize
The
for my
court
terminology.
can order
Right.
in these types of actions.
So in other words, just easy numbers, if you get awarded, $1,000 numbers, then you start subtracting all of the cost it took to get to that $1,000. So in
Yes,
essence, there is,
Often.
and then there's the 33% and all that stuff.
yes.
Right. I guess here's the main question, and I'll get to it, is why isn't the state of Tennessee, like they did for the other one that we just talked about,
Well-
going after this instead of just measly little Bradley County?
I'm going to be Bradley County.
Okay,
Hopefully
Bradley
get
County.
everybody signed up. And perhaps find insurance companies who have participated in and not use due diligence to determine the best
me-
interest of the people who use it. Let me just go one step
But
further.
my question is not that so much. I mean, why does Bradley County have to be involved? I mean, if I, as Milo Blake citizen, hired you to say, I think that XYZ pharmaceutical companies is charging too much, why can't that happen instead of sovereign, government kind of operation do it? I mean, why does Bradley County have to get involved in this
They don't at all. They do not have.
in order to
get
have a
involved.
class action?
What?
In order for this to take place?
Oh, they do not have to. They
Okay.
do not have to seek to have control over the funds that would be beneficial to the people of Bradley County who have been adversely impacted with the opioid. It would be a complex disbursement, much like what the legislature did with reference to the opioid after private class action filed. Yes, government proceeds were to be dispersed. Do you think that we got reimbursed for the purposes of determining what would be a reasonable portion of the monies which should be paid to Opioid Expressway USA right through I-75? Didn't happen. The mayor and Crystal can share with you the determination which was then established by the legislature as to how those settlement proceeds were going to be distributed. That's why I then waived any claim of any kind for the fees that we could have received, so that Bradley County would not be deprived of money at all.
And I guess in the contract you have, I was trying to pull it up, there's a person's name on there and it escapes me. I'll come back to it because I couldn't remember the name on the very last page. 1 second, please. Crystal Jesse?
Crystal Jesse,
Crystal-
yes.
Who is Crystal Jesse?
Crystal Jesse is an attorney out of Greenville who has participated in these types of class actions. She communicated with me and said, the counties that you represent and have been involved in litigation with, would you like to participate in this? Because I do believe that, and we did the research regarding the person who's really coordinating that, and I have given you a personal history of who this individual
Right.
is.
It just caught my attention when it says for your county, the contact person will be Crystal Jesse from the Jesse Law Firm. So I just had no idea.
I'm just joining with Crystal, is what it amounts to. And our division will be as a result of determinations made regarding the attorney's fees involving the entire class action. One of the other things is, this is not new. Eli Lilly has already offered $13.1 billion, I think. It's easily found on the internet. And most of the class actions have said, no, we're not going to accept that settlement.
Thank you. Any other commissioners on this committee like to speak?
Thank you, Mr. Chairman. Thank you, Ms. Freiberg, for being here today. Mr. Logan, thank you for being here today as well. Ms. Freiberg, I have a few questions for you, if you don't mind. in the contract, the 4-page contract, on the 5th paragraph, it states the litigation is intended to address a significant problem in the community. The litigation focuses on manufacturers, distributors, retailers, and pharmacy benefit managers and their role in the price fixing of insulin to drive up the cost for the counties that self-fund their insurance. And I guess this is a question for you and the mayor, but is Bradley County a self-funded insurance? Do we self-fund our insurance in Bradley County?
Yes, that section of this agreement, in my opinion at least, would not be applicable to Bradley County. So Bradley County is not self-funded. We have insurance for our employees that we purchase. So yes, that is not correct. The county, to my knowledge, does not buy insulin directly. We purchase insurance, and then our employees are sign up for that insurance. And certainly, we may have some employees that do get insulin through the insurance, but no, we do not directly purchase insulin, to my knowledge.
Ms. Freiberg, Mr. Logan stated just a few minutes ago that Bradley County does not need to get involved in this. This is about the people of Bradley County. But with this contract negotiation and with what we see here, is this about the people of Bradley County, or is this about the people who Bradley County government insures?
I'm not really sure. The first that I got involved in this was seeing the same documents that you all saw after the meeting. However, from the way the documents read, it's my assumption that we would only be asserting a claim based upon our purchase of insulin or our employees having insulin insurance related issues. If that's not the case, certainly we need to discuss that. So that's my assumption. I'm certainly in the county, I assume we have people that could be part of this class action, individuals who this might affect. And certainly if it gets to that point, they would be notified, as typical class members are, and would have an opportunity to be involved in the litigation.
In the last meeting, in our work session, I guess that was on Monday or last week, Mr. Logan stated that there are over 3,000, upwards of 3,000 people in Bradley County that are insulin dependent or use insulin. Since from your statement where this makes it look like it is for the Bradley County people, Bradley County government employees who are insured by insulin, how many people currently are insured by Bradley County, have health insurance within Bradley County?
Mayor might have a better idea than me. I do think most of our employees do sign up for our health insurance, but that might be
650, 700, something like that.
And out of those 650 or 700, is there any idea of how many people are insulin dependent or use insulin or diabetic products?
I do not have that information currently. We probably could seek that information, but I do not have that information currently.
So my question then would become is that if we sign this contract and we go into this agreement to file this class action lawsuit, would that only be for those people in Bradley County government who have Bradley County government health insurance at this point in time that would be a part of that class action for, that's where we would be paid out of disbursement. So like Commissioner Blake said, easy math, if we have, if the fund that gets awarded is $1,000 and that gets divided up by all these different counties or even $1 million, whatever it is, we would only get the percentage based off of the number of people in Bradley County government who has that health insurance. And that number would be taken after the 33% was taken out. Is that correct?
That's my assumption based upon what I have seen. And keep in mind, too, I just want to draw a distinction between this and the opioid case. In the opioid case, the concept was we as a county had standing because we had tangible costs related to ambulances and law enforcement and jail costs that were related to opioid use in our community. I'm not aware of that same type of analysis that can be applied to insulin, even though it may affect our citizens and money they pay. I don't know that we can make those same type of costs that we've outlaid costs related to insulin similar to that in the opioid case. So I do think it's it's distinguishable in a lot of ways, and is not the same as the claims that we articulated in the opioid case.
Another question that I have is in the third, sorry. Sorry, in that same paragraph where we were talking about self-funded, the last sentence of that paragraph states, the client agrees that they will not enroll in any other litigation concerning the price fixing of insulin with any other firms while this lawsuit is pending. I understand the term firm, but if the state attorney general decided to get into this case, if we sign this contract next week, the state attorney general decides to get in this case a month from now or a year from now, would we be able to sign up with the attorney general's office as well, or have them be able to manage this for us like they did during the opioids?
Well, the simple answer to that is no. It's a little more complex than that in the sense that the Attorney General's office doesn't ask people to sign up with them. They just pursue the interests of the state of Tennessee. And so when they pursue litigation, like in the opioid case, and get involved, they are doing it on behalf of the people of Tennessee. And so they would not ask us to do this. But yes, I do agree with you. And that is typical in agreement. If you sign an agreement with an attorney, you can't go out and hire a different attorney to file an action on behalf of you on the same type of claim. So that is typical, but you are correct that we would be agreeing that our only representation on this issue would be Mr. Fuller and whoever else he decides to associate with on the case.
The recovery fee of 33%, is that a standard thing that you see?
It is. Some people sort of see that as shockingly high, but if you're talking about complex litigation, which this obviously would be, the attorneys are taking on a risk that they don't recover anything, that they expend a lot of fees and they don't recover at all. So yes, I would certainly say that is a typical amount that you would see when you're not paying the attorney anything up front.
Another question that I have, in paragraph 6 of the contract states the purpose of the lawsuit is to pursue reimbursement for the overpricing of insulin and has led counties to pay substantially more. This language would indicate our county, not the citizens, are suffering from this issue of price fixing. Is that actually the case? Is Bradley County government, the funds that we pay, actually suffering from this?
Not to my knowledge, but
Let me comment. The funding that we pay for the insurance coverage is bound to a large extent on the diseases which we have. And as you and I discussed in the previous meeting, we know there are a lot of folks, even in this room, who have diabetic care. A lot of people, a lot of not only the folks who are covered by our insurance, and it is anticipated that we will be seeking a reimbursement of those fees that would impact the cost of our insurance policy from this county. It is also true that we ultimately intend for this to be to the benefit of everybody we can identify, easily done, who is treated by insulin as citizens of Bradley County. It is true that we're naming the county. We intend to amend the complaint to seek reimbursement for all citizens of Bradley County, and we can speak for the citizens of Bradley County. Now, the state of Tennessee can, there's no question, as they did previously, pass legislation which impacted that disbursement. I don't think, Mayor, did we get reimbursed specifically for the autopsies resulting from opioids? Did we get reimbursed for any of the opioid abuse and treatment expenses that went to the care and treatment of people in Bradley County? Not one of those funds. The state kept most of that money. They got to dole it out without regard to how many counties had autopsies and other things. This is certainly, at this point, from the standpoint of our involvement, or any involvement for the state of Tennessee, new ground. And it is true that an attorney would be foolish to waive fee they would earn on things that ultimately might be of benefit to Bradley County, to everybody who's insured, treatment of insulin, or they have additional deductibles that they have to pay over and above their insurance. I don't know what our deductible is, do you know? Our county insurance, we have any
For each
deductible?
employee?
Yes.
It depends on, the mayor probably knows more about it than I do, but it depends on what coverage you have.
Family or family.
So I just want you to know that I think everybody here knows that the issue of the questions which will arise for sure as to who's a beneficiary, who is not, until this case is fully resolved and settled under multi-district litigation, which will involve a combination of folks. And it does appear that the case that we have has been determined to be the site of the multi-district litigation. You talk about having a meeting with 150 attorneys involved, with a select committee then elected out of that group. It becomes very, very complex, far more than you can ever, you haven't been involved in, could ever believe. But perfectly all right with me, whatever decision the commission makes. I'm happy to be in, Bradley.
Well, I appreciate you saying those things, Mr. Logan. I do agree that I think that price fixing and the insulin cost in the United States are outrageous. As someone who has taken insulin for most of their life and who is on diabetic, I think it is outrageous. I think that for people who don't have insurance, that it is very difficult to be. And I know that currently there are multiple bills, one being Senate Bill 146, introduced by Senator Hawley and sponsored by Raphael Warnock of Georgia, is currently in to where it would cap the price of insulin throughout the entire United States, not just for Medicare Part D, Medicare patients and Medicaid patients, that it would cap it for everyone. So, and I understand, another question that I have is,
But
Th-
let me
this-
apologize for interrupting, but with reference to that, you do know that the passage of those laws, which hopefully can be enacted, will not refer back to the benefit that Eli Lilly said, hey, I don't want to be involved. Here's your $13 billion.
Are you talking about after the price cuts, the $13.5 million settlement that they had in the state of New Jersey?
They increased it ultimately several billion. I don't know those exact figures, but they initially did, and that's been opposed and not accepted.
The question that I do have though is that you said that it doesn't look back. So what is the time frame? What is the time frame of this class action lawsuit? When would it start and when would it end?
It's already started.
I'm talking about the dates for people. So if you took an Eli Lilly drug from
it will-
2020 to 2024, or
The case will not be over, as I suggested, in 3 to 5 years. Take that long. Get this all decided. The backdating of the benefit would be the statute of limitations, which would be applicable to, since the lawsuit's filed now, we will look back over the past 6 years under one statute. Under another statute, it's only 4 years. Look back from the date of the first filing. In this case, if we are successful, there is an earlier case, or actually two. They've been dismissed because the folks didn't, some of them have, because they didn't do the research necessary.
Ms. Freiberg, if we were to join this lawsuit and it went through the next 3, 4, 5 years and we were awarded this money, where would that money go? Would the employees of Bradley County who take the insulin and who use those, would they be the beneficiary of it? Or would it go to the county general fund, or would it go to pay for health insurance, or?
Well, it depends is the simple answer to that. I'm going to go back to the opioid lawsuit. In the opioid lawsuit, we weren't just given a pot of money and told, go spend it how you would like. And that is typical usually in the settlement of these cases if they're settled. So usually there are restrictions on the funds. If you're a typical plaintiff in a car wreck case or any other type of tort case, and you get a settlement, you get a check and you can spend it how you would like. But typically in this type of cases with governmental entities, that is not the case. But that's just typically. I can't say for sure that that we wouldn't just get a check and be told you can do with it what you like. I certainly can see Mayor Davis saying anything that we got should go toward health insurance costs, so if that's what it was supposed to be, if that's what the claim was about. So I certainly can see him wanting to do that and liking to do that, but I can't unfortunately tell you that there wouldn't be other restrictions on it or things that would tell us you got to spend it in these ways.
If this lawsuit and class action was to go through to the companies that were listed here, do those companies obviously have large insurance companies that they pay for these types of things? Would Bradley County, being that we're not going through this action, that we're not going through the state attorney general's office, and it is us ourselves along with other people who are getting involved, would we be subject to subrogation of the contract by those insurance companies?
That's another question that's a little bit difficult to answer. Anytime you file a lawsuit, there's always a potential that defendants could come back and try to seek some sort of remuneration from you for suing them. I would say it's atypical for that to be successful unless your claim was frivolous, but I certainly can't tell you that it couldn't happen, if that makes sense.
Outside of the contract items, I would like to know, is the state attorney general is any position to pursue this, any or all of the insurance companies listed? If the state has that desire to pursue this in short order, would we be wise to wait for the movement of their office before signing contracts with outside counsel? In your opinion, as a county attorney?
I certainly think it would always be in the best interest of the county to not sort of do it ourselves if we don't have to. I mean, certainly in the case of the opioid case, you know, it made it, and there was communications with our local district attorney about how that would happen. And so, yes, if that is an option, I certainly think that is preferable to having to hire independent counsel, regardless of who that might be. So yes, if that's an option, I certainly think it's preferable. I don't have enough information to know if that is feasible or if they are. Unfortunately, I can't tell you whether or not they will or will not pursue this. So I can't really tell you that at this point.
As legal counsel, and this is my final question, so I do apologize for all of them, for the many questions that I have. As legal counsel for Bradley County, what is your recommendation for this governing body and the facts of what you know and what we know, and also of what we should do in this contract? Is this a favorable contract for Bradley County? Does this contract put us in a tough spot if the AG's office of the state of Tennessee decides to get involved like they did in opioids?
As chairman, I don't think you ought to answer that question. You think so? I know, as she's well, I'm saying I don't know if that's an appropriate question to ask our county attorney, whether a particular, yeah,
Point of
go
order,
ahead.
Mr. Chairman. She is our attorney.
That's right.
The day that, and he's an attorney, and the day that, and we're client. The
I
day
agree with
that a
that.
client can't ask their attorney for a recommendation, I mean.
Anytime
maybe
privately, but when
uncomfortable,
you
but
do
it is a
publicly, you're
legitimate
putting
question.
this.
We're asking our county attorney what she thinks about what's going on. I think it's a legitimate question. Should be asked and answered.
I concur with you that we should be able to ask our county attorney that, but I don't know that we should ask in a public session that she respond to. Well, maybe she can share with the mayor to us how she feels, but I think it's putting her professionally on the spot here to say that another attorney should not be participating. So,
Mr. Chairman, to clarify my question, it's not that another attorney should be participating for us.
no.
It's that as the 14 of us, as commissioners duly elected by the people of Bradley County, are we doing the right thing for the people of Bradley County? Are we doing the right thing for the employees of Bradley County, where we vote on their health insurance, where we vote on their benefits, and where we vote to fund those mechanisms? Is this litigation, is this class action lawsuit and getting involved in it, is this the best interest of Bradley County? And I understand and I appreciate what Mr. Logan and his firm have done for the city of Cleveland and for the Bradley County for 50, 60 years. They've done an excellent job. But Mr. Logan, while he has, I know personally, I know Mr. Logan personally, and I know that he has the best interest for Bradley County and for the citizens of Cleveland. But I also know that Ms. Freiberg is the county attorney for Bradley County, and it is her job. It is her job to look out for the litigation and for the laws and for the legal standings of all of Bradley County. And as a county commissioner, you know, I would love to know her opinion on this, because I'm not an attorney by any chance. I took one business law class years ago at Lee University. It was at 8 a.m. and I slept through half of it, right? So I don't know the questions, and I don't know what I'm voting on, and I would appreciate to know. If Ms. Freiberg doesn't wish to answer them in a public setting, you know, it is your prerogative as chairman to go into that executive session. I don't mind having that answer in an executive session, whether that's today or whether that's with all you know, commissioners before the next voting session meeting where this is on it. But I would like to be able to have an answer to that question, to know if in her legal opinion, if she thinks that this is a good thing for us, for Bradley County.
I don't disagree that she could have the right to tell each one of us individually. We want to ask individually, and I ask her individually many questions regarding this. I just don't think a public setting at this point is appropriate for another attorney to tell whether we should support, and let's go out to the entire public at this point. So that's my opinion in this. You can.
Chairman, I might be able to simplify this. I think a portion of what he asked me, that was give Commissioner Rogers some credit, about 8-part question that he asked over there, which was pretty complicated. But I do think there are some pieces of that I certainly can answer that may be helpful, and then certainly you all can ask for at any point in time an attorney-client privilege session, which I probably could have more comments at that point. So I guess to the latter part of your question, which was, is this agreement fair? That essentially the agreement that has been presented to us. And are there issues with it? I do think in any time you have an agreement or a contract, and I think Mr. Logan would agree with me on this, you always have the right to negotiate certain lines or certain provisions of an agreement. I don't know whether or not changes or suggestions are allowed to something like this, typically from or whether they say, take it or leave it, sign this. We always, if there's provisions in a contract that the county doesn't like or thinks are not fair, we certainly ask that those be stricken, amended, changed. So I do think that some of the language in this and some of the concerns that have been raised would need to be looked at least in order to sign it. So I do think that there are a couple things in here, and most importantly, the one, and I think Mr. Logan would agree with this too, it's just not true that we're self-funded. So that would need to be changed and altered. It may be that most of the counties that they're discussing with are self-funded. I don't know. So we obviously would need to address that. So there are some things in there that if you all wanted to proceed with voting on this, I would like to make some changes to this. With your, obviously, direction to do that. But those things would happen sort of behind the scenes internally, which is a negotiation process where you say, these are changes we'd like to see. Mr. Logan's office would respond back, either yes, we can make those, or no, we can't. So that's typically how those work. So, I do think that there's things that we could do to make sure that the agreement is what we want it to be, so to speak.
Just one question, if I may. Chairman.
Yes, you may.
Am I correct that Bradley County does provide a health insurance benefit to some of its employees, not all?
All of its employees, absolutely.
Okay. And that cost if it is less, could result in county prorated benefit of that cost attributed to rate, which is available.
Yes, if we could establish that our rates were higher based on price fixing for insulin, certainly.
County funding potential benefit at this point is obvious, available if there's any merit. Sufficient.
Yes.
Thank you.
Jimmy, let me ask you two questions on the way out. My chance. In page 6 here, the litigation is intended to address a significant problem in the community. Litigation focuses on manufacturers, distributors, retailers, pharmacy, benefit managers, and their role in price fixing of insulin to drive up the cost for the counties self-funding their health insurance. And then you're also saying you will not be working with the local pharmaceutical groups, but we're going to be looking at manufacturers, distributors, retailers, pharmacy. You're going to do that on a global plane,
Yes.
correct?
Now, we might come back if the Walgreens pharmacy
Right.
that we might come back for this clear
Imaging local.
certain local.
Right.
I do believe potentially slow down
Mm-hmm.
providers
Okay.
from the distributors. That's what that portion.
Final question for me. The attorneys, this is the next paragraph. The attorneys intend to present a damage model design to abate the price fixing crisis. What is that?
It is a design which we've used in other litigation, including opioid. Terminate back pharmacy cost.
Yeah.
Bradley.
Right.
Understanding is I did not get a final figure, a good figure. I threw out more than 3,000. It's for sure more than 3,000. I've gotten estimates that make 3,000 look very small. Treatment. Go back. I want you. I didn't. I would. I have helping all the way.
Hmm.
Job. Years. Want us to advise them. Well, that's fine. Told them.
Thank you, Mr. Logan. You've been a fine contributor for my 14 years. I appreciate what you've done for Bradley County. Thank you. Okay, we still have resolution here. Do we have any action we would like to take at this point or further discussion? Thank you for the questions that we've had here. Denny Collins would have been here with many of those questions. He was unable to be here due to his employment as Bradley County School. Any other action on this solution? This committee move forward to table it. We want to have a resolution. We are in new business. We're in resolution approving the legal service contract with Mr. Logan. On the floor. What would you like to do with this? You had discussion. What would you like to recommend to the commission or leave it for further discussion with the commission?
Chairman, I just did want to point out, it's actually already on the agenda
For
at the
Monday.
direction of Commissioner Slater.
Right.
So the resolution as it's written is on the agenda for your next voting
So we're
session,
voting.
is my understanding. So just
And
wanted to
basically-
point that out.
Basically, what we intended this meeting to be was a discussion meeting. I think with two of our members that really asked that we have this. We've had this dialogue. If there's no further action, that you have further action you'd like to take, we'll just take this up at the meeting tonight. Correct?
You mean next Monday night?
Monday night.
Yeah, the meeting
This is Wednesday.
next
Monday.
Yes.
So, is there further action to take? Any other? We do have one action that we need to
Yeah,
take
this
a look at.
this
Yeah,
is totally different.
totally. Yes. Go ahead.
Um,
Mr. Blake.
Yeah, thank you, Mr. Chairman, appreciate it. Crystal, I'll read this and I'll get to you, but basically, we received a communication, Commissioner Collins, Commissioner Thompson, Commissioner Gilbert, and I, are gonna, a house located on 1405 6th Street and 485 Lowry Street. Lowry Street is a dividing line between the 3rd and 4th district, with the church being located on the 3rd district and the house on the 4th district. Gentleman is writing to express his concern about the growing homelessness camp that is located in my neighborhood, almost directly across the street from the church. Over the past few months, the traffic in and out of this property, as well as the amount of accumulated trash on the property, has greatly increased. It is unsightly, unsafe, and general nuisance to the residents of this neighborhood. I believe the property owner on record is deceased. I think that's the key point there. And I see on the tax commissioner's website that the property taxes are in arrear. And he's requesting a sense. What is, if I want to assist or this commission or whatever, what is my first step or our first step on getting any kind of corrective action or doing anything on that? The key point, I guess, was told to me by our environmental officer is that the property owner is deceased. So who do you go after?
Yes, and am I assuming correctly that individuals are being on the property that are not, I mean, they're essentially, they're not allowed to be there, they're not being told they can be there, but there's no one there to tell them to leave, is that
I
correct?
believe so. We call it squatters, whatever you call it.
Yes, we certainly can, through our environmental court process, go after and we just finished one that was like this, and got it cleaned up, which was a property that the owners were deceased, and you try to look for heirs, and you try to, so from the standpoint of cleaning up the property, we can take action on that, and that does help,
So
because
what's the catalyst? What needs, do I need to make a motion? Do I need to send it to a committee? Do I need to
there
just
would
let you
need
do
to
your
be,
job?
to start that process, there would
Okay.
need to be a complaint based on the property,
Can
to
this,
Tim Mason that it doesn't meet our environmental resolution. So that would need to be, though, that the condition of the property is there's garbage, there's debris, so it would need to be in violation. So when he gets a complaint, he would go out and look at it and assess whether or not he thinks it violates the resolution.
okay,
If it does, he engages then with, if they're deceased, he will look for heirs and try to engage and get them to clean up the property, get them to tell people not to be there, those types of things. If that doesn't work, then we proceed with the environmental
okay.
court
So what I
process.
hear you saying is this citizen needs to formally request the environmental officer to take action.
Make a complaint, yes.
Make a complaint or
Yes.
whatever. That's all I want to know is how I get the
Yes.
ball rolling. Thank you, Mr. Chairman. That's all I have.
Mr. Chairman. I have a question. The question that I proposed to Ms. Freiberg, I don't really feel like the question, part of that question was answered, but the entire question, while it was an 8-part question, was not fully answered. I guess I have a question for Ms. Freiberg. As a non-member of this committee, am I allowed to ask for a attorney-client privilege meeting before our next voting session with all commissioners for you to be able to answer that question and any other questions that might come up?
Yes, I would suggest that you get with Chairman Cry and ask him, make the request to him that he schedule that and do that. We do not, the media is not allowed in the meeting, but we do need to give notice that we're having a meeting if it's a meeting. So we would need to do the 48 hours and then, certainly get with everybody as far as scheduling. So yes, but like I said, I would suggest you, because Chairman Cry would need to.
Do I need to make
formalize
that
the
request
schedule.
directly to myself, to Chairman Cry, or can I make that request through Ms. Moultrie?
You could do that either way.
Ms. Moultrie, I would like to formally request an executive session meeting, attorney-client privilege meeting, before our next voting session with Ms. Freiberg with a full commission to Chairman Cry.
And we certainly could do it right before the meeting as well. We do that
Sure.
that often. And if it's limited to the question that you posed earlier, I wouldn't think that would take more than 10 or 15 minutes to answer.
And to explain the chair, I did not think this was appropriate to ask that question to you in this meeting. So that's why I moved that from this meeting, and I was going to move toward a client attorney privilege. So that's where any of those types, you are our attorney, you are his attorney, and you are a public attorney. So thank you for what you do for us. I don't think this was the forum for you to express yourself. Thank you. Any other? This meeting's adjourned. Oh, whoa, wait just a second. We have nobody here, but I would like to ask the people on the last row, middle row, first row, if you'd like to speak at this time. Those in the middle. This is a requirement, and we want anyone in the audience to speak. If they'd like, you get 5 minutes. Grant? Oh, yeah, Grant, speak to us. Say something from the press. This meeting is adjourned.